Trust versus will. Which one do you actually need? I'm going to break this down completely today. We'll look at what each one actually does, when you need a will versus when you need a trust, the real cost comparison between the two, because most people get this wrong, and then how your real estate factors into this decision. Because here's what happens. Someone tells you that you need a trust. You go get quotes and it's $3, $4, $5,000. Then someone else comes along and they say, just get a will for $300. And now you're stuck wondering, am I wasting money? Am I leaving my family exposed? This is such a great question, and I hear this all the time. What you're dealing with is called a death decision. It's one of the 12 Ds of the life transitions that I walk families through. And here's what most people miss. This isn't just a simple yes or no answer. It actually depends on your specific situation. So we'll look at this through the three angles that we always go through. First, your life. What is your season that you're currently in? And then what your family structure looks like, and then what you're trying to actually protect. And then second, we'll look at the wealth side. We're going to run the real cost numbers because most people compare the wrong costs. And then third, we'll look at the real estate piece because property changes this calculation in most ways that attorneys don't explain unless you ask the right questions. Now, let me start with the basics because if you don't understand what each one actually does, none of the rest of this makes any sense whatsoever. Let's start with a will. It is a legal document that says who gets your stuff when you die. That's it. You write it, you sign it, you put it in a drawer. Then, when you pass away, that will goes through a court process called probate. The court is going to validate it, oversee the distribution of your assets, the things that you own, and make sure that your debts get paid before anyone inherits anything. Now, a trust, that is different. A trust is a legal entity. Think of it like a box that holds your assets. You create the box, you move your assets into it, and then you write the rules for how the assets get distributed whenever you die. The key difference here is trusts bypass probate entirely because the trust owns the assets, not you personally. There's nothing for the court to validate or oversee when you pass away. Now, here's where people do get confused. They hear trust and they think that that means their assets are locked away where they can't touch them whatsoever. And that's not how it works. With a revocable living trust, which is what 99% of the people get, you control everything. You can change it, modify it, dissolve it entirely, whatever your prerogative is. You're the trustee, meaning the one making the decisions, while you're alive. Nothing changes how you manage your day-to-day. Now, think of a will as instructions for after you die. Think of a trust, again, as a container that holds your assets now and has built-in instructions for later. That container just happens to skip the court system. There are 5 key differences, though, that we should absolutely talk about. And difference number 1 is that probate wills go through probate, always. That means a court process that takes anywhere from 6 months to 2 years, depending on your state and how complex your estate is. In Colorado, simple estates, they might take 8 to 12 months. Complicated estates, though, with property in multiple states or family disputes, 18 months or more. Trusts skip probate completely. When you die, the successor trustee, that's the person that you name to take over, steps in immediately. They distribute the assets according to your instructions. No court, no waiting, no judge signing off on anything. Difference number 2, privacy. When a will goes through probate, it becomes public record. Anyone can look up what you owned, who you left it to, and how much everything was worth. If you own a house worth $600,000 and you leave it to your kids, that information is available to anyone who wants to search court records. Now, trusts, they are private. Nobody knows what's in your trust except the people that you choose to tell. Your assets, your beneficiaries, your instructions, all that stays confidential. Remember, in the box. Difference number 3, control and flexibility. A will is simple. You write it and you're done. You can update it whenever you want, but once you die, it does exactly what it says. If you left everything to your daughter and she's 21, she gets everything immediately, even if she's not ready for it. A trust, that lets you build in conditions. You can say your daughter gets 25% at age 25, another 25% at 30, and the rest at 35. You can say the trust pays for college, but nothing else until she's 30. You can protect assets from a child's divorce or creditors. You have way more control over how and when assets actually get distributed. Difference number 4, and this is real estate across state lines. Here's where it gets expensive with a will. Let's just say you own your primary home in Colorado and you've got a rental property in Arizona. When you die with just a will, your estate, it actually has to go through probate in both states. Now, that means 2 separate court processes, 2 sets of attorney fees, double the time, double the cost. Now, with a trust, though, it doesn't matter how many states you own property in. The trust owns all of it. So when you die, there's no probate anywhere. Your successor trustee handles everything. One process. Let's look at difference number 5, and that is incapacity planning. This is the one that most people don't think about until it's too late. If you only have a will and you become mentally incapacitated, your family has to go to court to get conservatorship or guardianship just to manage your finances. That's expensive and time consuming, and it happens while you're still alive. A trust handles incapacity automatically. If you can't manage your affairs, your successor trustees, they step in, no court involvement whatsoever. This is actually one of the biggest advantages of a trust that doesn't get talked about. Let me give you the situations where a simple will works fine and a trust is overkill. First, you're young. You don't own much and you just want something in place. If you're 30 years old, renting an apartment, and your biggest asset is a $10,000 car, you don't need a trust. Get a will. Second, you own property in only one state, your estate is straightforward, and you don't mind probate. If you got a house worth $300,000 or $400,000, some retirement accounts, maybe $50,000 in a savings, and everything's simple, a will works. Yes, your family will go through probate, but if your estate is under $500,000, there's no family drama, probate might just be the best option for you. Third, you don't care about privacy. If it doesn't bother you that your estate becomes public record, that is one less reason to get a trust. Fourth reason, you've got beneficiaries named on everything. Here's something most people don't know. If your house is the only thing going through probate because everything else has a beneficiary designation, you might not actually need a trust. And retirement accounts, life insurance payable on death, bank accounts, all those bypass probate automatically if you name the beneficiaries within the administrative section of the website or whatever paperwork you have there. So, when do you need a trust? Let's talk about when a trust stops being optional and actually starts being smart. There are 5 situations where I'd tell almost anyone, get the trust. First, you own real estate in multiple states. We already covered this, but it's worth repeating. If you've got property in 2 or more states, the cost of a trust, $2,500 to $4,000, maybe $5,000, is way cheaper than going through probate in multiple states. I've seen families, they spend $15,000 to $20,000 on multi-state probate, and it's needless. Get the trust. Second, your estate is worth more than $500,000. Once you cross that threshold, the probate gets more expensive and more complicated. The attorney fees, of course, go up. Court costs, those go up. Timelines extend. And at that level, the cost of a trust, you can view it as a cheap insurance policy against probate costs. Third, you've got minor children or young adult children who aren't quite ready for a lump sum. If you die tomorrow and your 18-year-old inherits $300,000, that's probably not going to end well. A trust, though, that lets you stagger the distributions, set conditions, whatever your desires are. That money doesn't get into their hands until they're mature enough to handle it based on the conditions that you set. Fourth, you want privacy. If you're in a situation where you don't want the public knowing what you owned or who you left it to, maybe you've even got a blended family. Maybe there's potential for family disputes. Maybe you just value privacy. Nothing wrong with that. Get a trust. Everything stays private. Fifth reason for a trust. You're worried about incapacity. This is the big one that people miss. If you're in your 50s or 60s and you've actually seen what happens when someone has a stroke or develops dementia without the proper planning, you know how brutal the conservatorship process is. A trust, it solves that problem completely. I worked with a client last year, and let's call her Sarah. She was 58, owned a home worth $450,000, had a rental property in New Mexico, and they were starting to worry about what happens when something happens to her. So her mom had gone through a conservatorship battle 3 years prior, so she had immediate experience there. And Sarah watched it tear the family apart. She got a trust set up for $3,200. 6 months later, though, she had a stroke. Her daughter became the immediate successor trustee, managed everything. Sarah recovered, and the transition back, it was seamless. That trust was worth every penny in that situation. Let's talk about the real cost comparison everyone gets wrong. And that's people compare the setup cost of a will versus the setup cost of a trust. That's the wrong comparison. Here's the real math. A simple will, several $100s depending on complexity. Now, a revocable living trust, though, $2,500 to $5,000, depending on your state and your attorney. But that's not the total cost. The total cost includes what happens when you die. So probate, again, in Colorado, an estate worth $400,000, typically 4 to 8% of the estate value. That's $16,000 to $32,000 in attorney fees, court costs, and executor fees, plus 8 to 18 months of timeline, depending on the situation. A trust, though, again, you pay the setup costs once, and when you die, there's no probate. Your successor trustee distributes assets according to your instructions, and there might be a couple $1,000s in attorney fees to help with the transfer, but that's it. So when someone says a trust is too expensive, they're comparing $3,000 now versus $300 now. But that's not, again, the fair comparison. The fair comparison is $3,000 total now versus $300 now plus thousands of dollars and time and headache later. The trust is cheaper, and depending on how you value your time, you're just paying up front instead of leaving the bill for your family. Let me talk about the real estate piece specifically, because this is where I see people make very expensive mistakes. If you own your primary home and you're thinking about buying a rental property or a vacation property, that's the moment to get a trust. Not after you buy it, before. Transferring property into the trust after you buy it, that means retitling the property, which could, not guaranteed, not all lenders are like this, trigger due on sale clauses with some lenders, and it creates paperwork headaches at the end of the day. Thing to do here, though, is to validate that your mortgage allows for it and that there wouldn't be any issues with it. Here's what I tell clients who are building real estate portfolios. Get the trust set up first, then buy the properties in the trust's name from day one if the lender allows for it. Some of them say you have to buy it individually first, then transfer it in. The former, that is way cleaner, but this gives you a question to ask your lender as far as the best way to do it. Either way, the final destination for the property should be the trust itself. Second thing, if you're military and you're moving every few years, buying homes and converting them to rentals, look, that is an incredible wealth plan. You almost certainly need a trust. I work with a lot of military families who own properties in 3 or 4 different states. Without a trust, though, when they die, their family is looking at probate in every single state. And let's be frank, you are in a high-risk profession. That is a nightmare that you would leave behind for your heirs. Third, if you're planning to downsize and you're worried about Medicaid planning or long-term care costs, some types of trusts can actually help protect your home equity. That's a different kind of trust than what we've been talking about. That's an irrevocable trust, but it's worth mentioning because a lot of people in their 60s and 70s, they're thinking about this. So how do you decide? I want you to ask yourself these questions. Do I own property in more than one state? If yes, get a trust. Is my estate worth more than $500,000? If yes, strongly consider a trust. Do I have minor children or young adults who shouldn't inherit everything immediately? If yes, get a trust. Do I value privacy or is there potential for family disputes? If yes, get a trust. Am I over 50 and worried about incapacity planning? If yes, seriously consider getting a trust. If you answer no to all of these, a will is probably just fine for now. But here's the key. This isn't a one-time decision. Remember, life is an active sport. Your situation changes, and so your strategy has to change. When you buy that second property, when you hit 50, when your net worth crosses 500,000, revisit this conversation. The next steps: talk to an estate planning attorney in your state. I'm not an attorney. This is educational information, not legal advice. These are concepts to consider, thought processes to go through. What works in Colorado might not work in California or Texas. If you want help thinking through this as it relates to your real estate, or if you're buying or selling property and trying to figure out what affects your estate plan, I'm happy to talk through it with you. You can book using the caption below. You'll see my Calendly link there. I have these conversations all day, every day, because I love just exploring the concepts alongside you and equipping you to be set up for success. Here's the bottom line. A trust versus a will isn't about which one is better. It's about which one fits your specific situation. If you're young, renting, don't own much, a will is just fine. If you own multiple properties, have a complex family, if you want to avoid probate and protect your privacy, get a trust. Don't let anyone scare you into a decision. This is about your family, your assets, and your peace of mind. Take the time to understand what you actually need to make a confident decision. Now, if you're watching this because you're thinking about downsizing, or you've inherited property and you're trying to figure out what to do with it, I've got a whole other video on that. It's called What Happens After Death? Probate Process Explained. I'll link it in the description below. It walks through exactly what your family will deal with if you don't have your proper estate planning in place. Thanks for watching. Click the like and subscribe button, and look forward to seeing you in the next one.